This is The Law Show on CL 650. Now back to the show.
These boots are made for walking, and that's just what they'll do. One of these days, these boots are gonna walk all over you.
And welcome back to The Law Show on CL 650. David Halkett joins me in studio, partner at McQuarrie Hunter, and Sarah Morse, associate, and both in the family law department at McQuarrie Hunter. Now, we've talked about division of assets and getting settlements and support for children and spouses. How often can these be amended? So it's 2017, and, you know, how often did people come back to you and say, listen, I need to go back and get some kind of change?
Well, certainly support and children issues are always variable.
Yeah.
Usually,
so once it's not locked in stone, right?
No, usually has to be some kind of a change in circumstances, and it has to be material. So it's not like my income went from 100 to 101,
sure,
kind of thing. But if there's a change in circumstances, money-wise, you should be paying the difference as you go along. Mm-hmm. Spousal is variable. Obviously, if the recipient obtains employment or if gets into a new relationship, either common law is together for 2 years or is married, that can be a factor in reviewing whether or not you should be paying spousal, and if you still have to pay, how much. Assets usually, though, once they're divided, that's the end of it. Especially if it's an order, usually it can't be varied unless there was a mistake of some kind. But if you have an agreement that was deemed to be unfair, they can revisit the assets later on. So they can look at a separation agreement again or a marriage agreement of some kind.
Now, Sarah, how many people come and say, okay, I'm getting a divorce, just give me the one lump sum payment, I want this done with, pay them, give them the money or give them the house or whatever it is just to get it done with instead of protracting it out over years?
It's hard to say because it's going to depend on the process. I mean, sometimes people come in and it is that quick and that easy. If both people are on the same page and there's, just the family home, one person is staying in it, the child's already they've agreed that the child's going to go equal time to both houses, it can be that simple and we can do a really basic separation agreement. But other times you can't avoid it being somewhat protracted based on the assets or disclosure or financial information or disagreement about where the kids are going to reside and things of that nature. So our goal is definitely to try and make it as quick and as easy, as painless as possible, but you can't change the facts.
And I tend not to want a person to just come in and just take a lump sum like that, because that's the kind of agreement that you have buyer's remorse down the road. Because people tend to burn through money, whether it be intentionally themselves, they've spent it, or some new person comes into life and spends the money and then it's gone and there you go. Often when someone comes in, and they say they just want a lump sum, they want this and they want it done, usually I tell them to at least go through the process to get the disclosure first. And it may be that that's a fair amount. Like I've had people come in and say, my spouse has offered me X and I think it's fair. And I always say, well, until I receive even the most basic of disclosure of assets, income, etc., I can't tell if it is or not. So I can't recommend they do that. It does kind of put Sarah and me at risk ourselves for a claim down the road. And we don't
if you didn't do your due diligence.
Exactly. And because you can't agree to something you don't know what you're agreeing to.
You don't know what you don't know.
Exactly.
All right. Now, we live in a city where everything is very expensive, especially real estate, and people live in different sort of kinds of real estate. You might have a co-op apartment or a strata, or you own your own detached house. Does it matter?
No, the type of asset doesn't really matter insofar as a strata. You just you sell it and you get the equity. House the same. Co-op, I think it depends on. I haven't had a case with a co-op in must be 15, 20 years.
Right.
It's whatever the value is and what you could sell it for. Right. So it's whatever the fair market value is of the asset. The tough ones are some of the lands on Musqueam where there's a leasehold and it's what someone will pay for. So again, they're harder to value insofar as you don't know.
Because you're not selling land, you're just selling the house and the lease, right?
Exactly. And so the payment can go up. So it's what someone on a third party, arm's length third party will pay for the asset is what the value is to be divided.
Okay. Now, are there any other types of ownership agreements that you would have? Well, the one that I was thinking about is, okay, so we get married, and I've had a family access to a family cabin or cottage or chalet in Whistler, and we've been going every weekend skiing. And now you're getting divorced. What does your spouse have a claim against a property that is maybe you have with 4 or 5 other siblings?
Yeah. Well, in that situation, I'll assume that everyone was on title, so all siblings were on title and had their 20%. Your spouse would be entitled to half of the growth of your portion during the relationship. So if it was valued historically at $1 million, you had 20%, so it's 200, and you're together for 10 years and it's worth $2 million, and you still have the 20%, the growth would be another $200,000 in yours. That would be divisible.
Mm-hmm. You ever get those ones where they say, I don't want the money, I still want access to the family chalet, but I'm sure the brothers and sisters don't want you there.
Yeah, that's a complicating factor, and usually a court will take that into account and say that, I can't give you the access to it because the other parties have to
agree.
Now, technically, I guess a court could order that both be on title, that the 20% be divided. It's subject, of course, to what agreements are in place as to whether or not the others are allowed to have you on, et cetera. But
now, what about a corporation? Your husband runs his own business, and the money really is flowing through the business and not really through personal assets. So how do you tackle that? And is that where you bring in somebody else from another department at Macquarie Hunter?
Well, in that one, usually the interest that you have is in the shares, not in the business itself. So if the husband or the wife has all the shares, your interest is in the shares itself. So you're entitled to 1/2 the value of the shares. You could set it up so that half the shares get transferred to you, but most don't do that. They'll just you get a valuation of the business and you get bought out, whether against other assets.
Mm-hmm. So is it more complicated? Are you seeing more of those? Because a lot of people are running they're a consultant or something, and they have a business that's really a way to.
And those are harder to value. The ones where there's no hard assets, where it's goodwill, where it's
their name.
It's their names, an IT business or a consulting business, and those are a lot harder to value.
Well, especially in a lot of lawyers do their work through a law corp.
Mm-hmm.
Like I'm not a law corp myself, but a lot do that. I couldn't sell my corp to someone else.
It's really just the value is you, right?
Exactly. So, we all have when you're a partner, you have your equity in the firm and such, but it's still determining what that actually amount is when it comes to it. And we have that for dental practices, medical practices, and everything. So often you have to bring in a certain kind of valuator who knows how to value those assets themselves.
Now, what about people who set up a business to split income? So, one person's really doing all of the work, but everything's getting paid into a business, and then those assets are split between the husband and the wife for tax purposes. Yeah. So does that change anything?
Yeah, well, usually that flows into support issues, and you impute the income that was paid to the spouse back. So, for example, Sarah and I own a business. She's at home with the children, and I'm the one who is earning all the income, but I've paid her half the income. When we separate, I'm not going to be able to say that, well, she made $40,000 last year. She didn't see a dime of it. It all went into the joint money. The money would flow back to me, and she'd be deemed to have like zero income, assuming she didn't work elsewhere, and I'd have all the income for those purposes.
Oh, so then it'd be split based on you having 100%.
Usually that's how it goes.
Yeah, we see that happen quite a bit with the income splitting, and then having to put it back to the person that was paying it out, because that person wasn't actually getting the money. It was just going into the joint bank account and being used by the family.
Interesting. All these variables.
Oh, yeah. And that's what the complicating thing is. There's a lot different structures business-wise than even when I started. People in those days, mostly you were either business owner or you got a T4. Now people are contracting with someone, and it's all over the place.
Yeah, because people have been downsized, right?
Yeah,
a lot of businesses don't want you on the books, so you have to be creative and make your own business, right?
Yeah. Exactly.
And okay. So any other forms of ownership that we should be aware of?
Well, the leasehold is a interesting one, because a lot of people say, we own a car, but they really are leasing the car, so it's not an asset.
Sure.
there's the difference between the
all you've owned is a payment.
Exactly. There's also factors of trusts and whether or not you are entitled to a portion of a trust and how that gets divided. Where we practice, we're starting to see a lot more of that than even like 10 years ago, because a lot more complex businesses are out in the valley than it used to be. The people who dealt with trusts and corporations, they were all based downtown.
Right.
Now it's all the way out in the valley.
So why is that? Is that multi-generational families that live together? Is that part of the...
No, I think it's just that a lot of people have made a lot of money through real estate or businesses, and they want to try and control how their children get. I guess they don't want to run into an Eaton situation where the grandchildren kind of blew all the money, right? So they can control it a bit more.
All right. We're continuing our conversation. We're talking about division of assets when it comes to family breaking up. We have our family lawyers here, David Halkett from Macquarie Hunter and Sarah Morse, and we'll continue next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.